All right, the final case on the docket will be Doctors Company versus Plummer.
May it please the Court, Dinah Stein on behalf of the Doctors Company and Dr. Torres. With me at counsel table is Philip Mooring, who was one of the trial lawyers, and I would respectfully request 2 minutes for rebuttal.
How much?
2.
Okay.
Thank you, Your Honors. And it's the defense's position that a new trial is required because defense counsel essentially walked into a trial that was different than what they had spent many months preparing for, with new opinions, new exhibits, and frankly, changes in opinions from at least 3 witnesses. And I'll start with the giant pus ball boring through bone theory. Now, before the trial, the critical issue was what happened between Dr. Torres' 2 appointments, the December 18th and the February 25th appointment, because the issue was the defense contended there was a resolved infection that came back, and the plaintiffs contended that it never ended. It was a continuous and chronic situation. There was one expert prior to the trial who had testified, it was his opinion that it was chronic, and that was Dr. Brown, the plaintiff's standard of care expert. And he testified in his deposition that it was chronic. He was asked for proof of it. His proof was the history in the medical records complaining of pain, and when defense counsel point blank asked him if he had any other proof of that, he agreed that there was no proof. He said, "True, I have no proof." 3 other plaintiff's witnesses, Dr. Dreyer, the standard of care and causation expert, Dr. Anderson, who was a pathologist and a treater, the neurologist at the hospital, similarly had they didn't even opine in their depositions as to a chronic situation. Dr. Anderson, the only person who actually, the pathologist who had the body, said, "I have no proof of infection." I would defer to the clinicians on that. Dr. Dreyer didn't even think the December 18th appointment was important to causation. He was focused on the 25th of February, and the neurologist from the hospital, Dr. Dinkla, said he had no opinion either. He had simply looked at the EEG, some blood flow studies, and he said that what had happened and when the infection had started was irrelevant to his diagnosis. Well, of course, after the depositions, all of these witnesses were given, for the first time, CT scans and x-rays. The defense was never told about this. The defense had specifically asked these witnesses in deposition whether they would have new opinions at trial. It was denied. At trial, they came in, and for the first time, every one of them testified at trial that they had now looked at these, and these are all non-radiologists, they had now looked at these studies, had changed their opinions, and said the studies absolutely showed this massive pus ball that had been in the brain, or behind the ear, the entire time, boring through bone, and caused this communication in late February, to the point that Dr. Finley Brown on the stand, the standard of care expert, admitted in cross-examination, he was impeached with his deposition testimony. Defense counsel said, "You've changed your opinion, haven't you, since you've looked at these studies?" And he said, "I sure have." Now, the defense emphatically objected to all of this, moved for mistrials, and unfortunately it came in on this very critical issue, and the defense really wasn't in a position to either bring in
Let me ask you
Experts-
this.
yes, Your Honor.
The CT scans were available prior to their depositions, right?
Yes, it was in both parties' possession.
And were these doctors, Brown, Dreyer, Anderson, were they asked if they had reviewed the CT scans?
They were asked what records they had reviewed. I believe Dr. Anderson had looked at, he said he had looked at the labs and the CT report, not the scans. Dr. Dinkla testified that he had just looked at the EEG and the blood flow study. So he hadn't talked about looking at any scan, and he was a treater who was just talking about his treatment in his deposition. Dr. Dreyer didn't even have an opinion in his deposition as to the length of the infection.
So if after their depositions, they were shown the CT scans, and then based on those CT scans, we're going to have an opinion that they were supportive of the original opinion, what obligation was the plaintiff under? I mean, was correct interrogatories, or what would you say the law requires them to do at that time?
Very simple. Notify opposing counsel. Give opposing counsel time to either retake the depositions or, as defense counsel said at trial, bring in a radiologist, because that was a big problem. The defense originally had retained an expert radiologist, but then released him months before the trial because there were no radiological opinions, and also did not list the radiologist at Dr. Franklin at the hospital, who didn't report on any abscess or giant pus ball. And that was counsel's position. I would have listed a radiologist. Not only that, he would have deposed these experts to find out whether they were even qualified to render decisions on CT scans and x-rays. I mean, we have Dr. Anderson, who's a pathologist who does autopsies, and now he's looking at a live patient CT scan and rendering this new opinion, which, by the way, is additionally problematic because Dr. Anderson was point-blank asked in his deposition, and again, this is the person who hands-on had the body at the end of the day, was the tissue there? Was everything there? Were all the parts there? And he said yes. The only thing that had been dissected was the brain, but the tissue was intact. And so that was what he told the defense at deposition. And in fact, he was even asked at the end, are you going to have any more opinions? Because I don't want to be surprised at trial. He said, an autopsy is an autopsy. No, I don't expect any more opinions. Well, he came in during trial for the first time and changed his opinion and said, a large portion of the skull, not a large portion, but the critical portion of the skull had been sawed out and discarded by the prior autopsy company. Again, this is something that was asked in his deposition. The defense had no way of knowing about it, and the plaintiff absolutely had an obligation, if this was the case, to tell the defense prior to trial instead of in the middle of Dr. Anderson's testimony, which is when it first came out. And Dr. Anderson now took the position that the first autopsy company had discarded this bone. Had they left it, he would have looked at it and it would have shown infection. So again, that was something that was critically impossible for the defense to respond to. So now you have the three experts, well actually two experts, a quasi-treater and one treater, testifying with brand new testimony with something that the defense really couldn't respond to or rebut. And the trial court's position was to just cover it in cross-examination, which, of course, there's only so much you could do in front of the jury on cross. Now, to make matters worse, there was really only one witness at trial, I believe, who was really neutral, who could have corroborated the defendant's position, and that was Dr. Kelly. And the reason I say she's the only really neutral witness is because the defense did have two other witnesses, Dr. Rothbaum and the physician's assistant, Taylor. Those were both treaters. These are all people who saw Mr. Plummer before he passed away. And Taylor and Rothbaum, if you look at their testimony, I think the plaintiff really destroyed their credibility because they were accused of conspiring to cover up whatever their alleged negligence may have been. But Dr. Kelly was never accused of anything. She was the ER physician who saw Mr. Plummer on intake and was deposed, and she testified that she actually checked for things like mastoiditis, a pus ball. She checked the ear to see if it had essentially squishiness, is what you'd show disease with, and she corroborated the defense theories. And so unfortunately, that the plaintiff at trial successfully and emphatically argued very strongly to keep out her testimony, which it did.
I
Yes.
looked at the transcript on that. Actually, the judge kind of kept it out without the plaintiff even participating in the argument. But be that as
I
it
agree.
may, let me ask you this. The key on Dr. Kelly was things that she observed about the ER, correct?
Correct.
Okay. Did her records come into evidence?
It came in through, yes.
Okay.
Yes.
So my question is, on closing argument, were those observations noted or referenced by your trial counsel?
I believe so. I believe so. I read it this morning, but it's a big record.
Right.
But yes, and
If they weren't, would that kind of undermine how important the deposition was? If
I understand. I agree, and I don't want to say anything that's incorrect, so I'm not 100% sure. It was brought out by the defense in cross-examination of some of the witnesses to the extent he could, and as well as in direct examination. So the defense did make an effort to bring it out through other witness testimony. But the problem with that is, and I think there's a very definitive reason for Rule 1.330. First of all, that's a rule, and the case law says, and the Supreme Court has said that a trial court has to follow the rule. It's not discretionary if a testimony falls under it. Second of all, and I think the reason for this, one of the reasons, is the jury's allowed to hear the deponents, essentially their voice, to make their own determination through the deposition as to whether the intelligence of the witness, the credibility of the witness, the qualifications, which the jury never got to hear, and actually hear the witness through their deposition testimony
this wasn't a
speak.
video, right?
No, it was not. It was not. It was designated in the deposition. So that's true. But again, it was still large portions were designated where she did talk about her own memory, her own experience with the Mr. Plummer when he came into the emergency room. And just to talk to that, I mean, the Latour case, I believe, from the second district said it's not even sufficient to not allow in a deposition under this rule, but require a live testimony. In that case, the judge wouldn't allow the deposition, but the witness came in live, and they said that the person offering, the party offering the deposition, has the absolute right to present it. They're not required to bring in it through alternate means. And again, I think, the interesting thing with this rule is the case law interpreting it has a very, very high, I'd say not even quite an abuse of discretion standard of review, because it says that the court has to make the determination if the testimony qualifies. If it qualifies, unless there's some other overriding reason to not let it in, it comes in. And this basis that the court seemed to, and I guess plaintiff's counsel was arguing, which I still don't quite understand, that they didn't have a chance to properly develop cross-examination, is not even something that's contemplated by either the rule, or I don't even think it's contemplated by the case law. If someone has the right to bring in a deposition, I don't know that the fact that you weren't quite prepared to take it is a reason to keep it out. Now, I've seen case law where you can't require a party to present a discovery deposition in lieu of a trial deposition. That I understand, but certainly the rule 1.330 has been around a long time, and anyone taking a deposition of a treating physician, a skilled witness under the rule, no question, knows that this deposition is going to be admissible regardless of whether the witness is available. And of course, I submit that the parties showed and the plaintiff agreed she wasn't available either. And that was the other that point that was made, which I'm not sure why the court was requiring the defense to show that it subpoenaed her when it was agreed that the plaintiff subpoenaed her unsuccessfully. So again, we have now the striking of an entire witness who's the only person who saw the plaintiff, or the decedent, before he, when he came into the hospital and didn't have any credibility issues at trial. Now, of course, we also have the issue of the Levaquin. This was, of course, a 65-page package insert. Now, just for the background, we know, and admittedly, and in the records, Dr. Torres had given Mr. Plummer Levaquin samples on December 18th, and she testified that this was not for the ear. She admitted she didn't give anything for the ear because she thought he didn't have an infection, but she gave it for...
Sinusitis?
Correct, absolutely. And so it was really not even directly relevant issue. The plaintiff then, again, no witness mentioned package inserts, Levaquin during their depositions. The plaintiff knew about the Levaquin at least 9 months before trial. 2 days before trial, the plaintiff gave the defense a 65-page package insert in an exhibit exchange. And when the defense objected, the plaintiff contended they could bring it in. The objections were authenticity, predicate. To this day, nobody knows where this, well, nobody from the defense knows where this 65-page insert came from. Sorry, the timer just distracted me for a minute. In other words, we don't know if it came off the internet. Dr. Brown was asked, where do these come from? And he said, you can get it off the internet. So we don't know what year it was, whether Dr. Torres had it. It's just absolutely no predicate.
What was the theory about the Levaquin? Was the argument that it somehow contributed to the problem, or that it was prescribed in lieu of something else, or was it just generally to say, here's something the doctor did that they shouldn't have done, even though it's unrelated to this condition?
It's actually, that's an excellent question, because no, nobody said the Levaquin did any harm to Mr. Plummer. Nobody said that it shouldn't have been given for his sinusitis. The point of it was that the package insert said if you're going to give Levaquin, you have to do test a culture the bacteria, and so the plaintiffs used this to show that if you're going to give Levaquin, for whatever reason, you have to do a culture. And to not do a culture violates the standard of care, even though she gave it for a completely different reason.
Was he given Levaquin when he was in the hospital?
He was offered Levaquin, I think so. I think so. I know there was another time he was given Levaquin. But again, it wasn't even given for the ear. And I'm not sure what I still haven't figured out the plaintiff's notice argument, because they're saying it was given for notice, but there were no issues as to what Dr. Torres knew or didn't know. This was pure standard of care, and if you look at the testimony, it was absolutely used for this government standard of care to say, look, even the FDA says that you need to do a culture when Levaquin's given.
And is the tail end of that argument, and if you had done the culture, you would have discovered this problem? Was that part of the argument?
I think so, except for the fact that the culture would have been for the sinusitis, but I suppose, I'm not even sure if it was connected to causation, but I think that's a fair inference. But I think it was really used for standard of care. I mean, if you look at the testimony, it really seemed to be standard of care, because they were saying, doesn't a doctor, this is a standard of care? Yes, and a doctor has to follow the standard of care.
Well, leaving out the Levaquin, were they arguing that your client was obligated, or had, as far as their standard of care, to do a culture of the
Yes.
ear? Okay.
Yes, and so that was, as far as I can tell, that analogous to taking a textbook or
And
any.
was that an opinion that was provided in any of the discovery depositions
No.
by the doctors?
No, it wasn't even mentioned. And the plaintiff tries to take the position that Dr. Torres didn't disclose it, which, to them timely, which the record does not support that. This was in her record. And, talk about the plaintiffs accused the defense of not taking a thorough deposition. The plaintiffs never said to any of even Dr. Torres, well, what does this say?
Well,
Well, if it wasn't disclosed earlier, that wouldn't change their obligation once they found it and came up with new opinions.
Correct.
Provide opposing counsel with that information.
That's right, and that's absolutely right. And in fact, the defense did.
You're at 120, I just need to tell you.
Okay, so is this going to be what's left for the
Rebuttal, yeah.
the rebuttal? Then, and I mean, I'll follow up with these questions, but yes, I mean, it still should have been given. It was in her records. She answered questions very honestly in her deposition. She was being asked about prescriptions that were given for the ear. She was, for the proceeding doctor, she answered those. She was asked what prescription she gave for the ear. She answered that honestly. The defense never hid the ball on this and volunteered the information during.
Well, she said she didn't give prescription because, she didn't list this as something she gave a prescription for because she gave samples, right?
That's right, that's right. And if you look at the context.
That's kind of
if you look,
half hiding the ball at least.
if I would submit that she was, if you look at the preceding questions, they were directed towards the ear. I mean, they were really looking at the ear. But again, the defense did volunteer this to the plaintiff 9 months before the trial, so they knew. They absolutely knew about this. As far as the other issues, I think the part about the Florida Administrative Code and accusing Dr. Torres of fraud are well briefed. As far as both sides, it's, I think, set out, unless your honors have questions about that. And the Section 5 is really just the CAPS issue is just to preserve. We're going to rest on the briefs on that.
I'll give you 2 minutes for rebuttal, and I'll give appellee 22 minutes.
Thank you, your honors.
May it please the court, Brian Gowdy of Creed and Gowdy in Jacksonville on behalf of Nancy Plummer. Seated behind me is trial counsel.
Mr. Gowdy, can you explain what the relevance at trial, what the relevance of the Levaquin evidence was?
Sure. I think the first thing you need to start with is to go back to pages 771 and 777 of the trial transcript and read the judge's questions to defense counsel there. Because the issue got interjected because defense counsel insisted, despite the fact that Dr. Torres frankly lied in her deposition about the Levaquin when asked, that she was going to testify at trial that she gave Levaquin on the December 18th visit. And she twice, during this discussion, the trial judge twice asked the asked the defense counsel, is your client going to testify about this? And he said yes, and then that's when she made her ruling that I'm going to allow them to bring in this evidence about the package insert. And the package insert, which is what comes from the manufacturer, said before you administer this drug, you need to do a culture and susceptibility test. And that wasn't a new opinion. Dr. Brown gave that opinion in his depo. I'm sorry.
Well, didn't plaintiff's counsel raise the Levaquin right at the onset of the opening statement?
Yes, it got raised there, but
before, any discussion of cross-examination of.
Sure, but when the trial, it's very clear to me if you go back and you read from page 769 to 777 of the record that and what we have on this Levaquin issue is Dr. Torres concealed this fact during her depo, and all of our experts had developed their expert opinions on the assumption that they didn't know about the Levaquin. They were completely in the dark about it.
So when did they find out about that?
Well, it's not true that they found out. What Ms. Stein is referring to is, and Dr. Dreyer, who was the infectious disease expert for plaintiff, and when his deposition was taken in July of 2014, plaintiff's counsel misstated Dr. Torres's deposition testimony and represented that she had testified that she gave Levaquin. And if you read that, it's laid out in our brief, Dr. Dreyer was like, I don't remember that. Well, there's a good reason he didn't remember it. She didn't say that. As a matter of fact, she...
My question is when they found out about it. You're telling me when they didn't find out.
Well, I don't think it
When
was...
did they find out about it?
I don't think it's clear in the record, Your Honor.
They obviously found out about it sometime before 2 days before trial, when they provided an exhibit list and were now going to use the Levaquin.
I think it got learned over time when we started to depose the defense experts, but there was never...
When they discovered it, did you advise opposing counsel that your experts now had new opinions because they had new information about Levaquin?
No, but I think...
Did you have an obligation to tell opposing counsel if your experts were going to give opinions that they hadn't previously disclosed?
You know, Your Honor, with 20/20 hindsight, perhaps that would have been the better thing to do, and certainly...
Did you have not whether it's... Did you have an obligation
Well,
under the law to provide the opposing party with information about new opinions your experts were going to testify about if they hadn't previously been disclosed?
Your Honor, I don't think it's so black and white. I know you're trying to get me to say yes or no to that answer, and I don't think it was so clear at the time as it's being made out now post hoc. But I think
As a general rule, is there an obligation to
Yes.
provide opposing counsel if you have new opinions?
yes.
Why doesn't that general rule apply in this case, in your...
Well, because Binger's not about whether or not counsel should have done something. Binger is about whether or not the parties got a fair trial and whether there was unfair surprise. So we can talk the whole oral argument about whether or not plaintiff's counsel should or should not have done something, but that's not what the Binger analysis is about. It's about unfair surprise. And I think when this whole
Does unfair surprise equate to prejudice? Is that?
Well, prejudice, and not in the sense that it's bad testimony,
Right.
but that it's that you're not able to have a fair trial. And I think the reason I want to talk about Dr. Torres's concealment during her deposition is that got this whole ball of wax started. And she was asked point blank, one of the things I forgot to ask you, on December 18, 2009, can we go there quickly? Did you prescribe anything for him at that point? Answer, she's perusing the document, the medical record that has her handwriting that nobody can read. On that visit, I prescribed the Medrol pack. Says nothing about Levaquin. Our experts develop all their expert testimony without knowing anything about this Levaquin.
But the Levaquin was for sinusitis, not for the ear, correct?
That's what it's administered for, but she wanted to use that as a defense that she had given appropriate care. She was insistent, her defense counsel was insistent, I am going to talk about this to show that I gave appropriate care because her diagnosis was sinusitis. And so she wanted to say that, hey, I took care of this patient, and she concealed this fact at her depot. Now, did we later learn? Yes. And in a perfect world with a perfect trial, would this have been disclosed? Yes, but the perfect world would have required Dr. Torres, and it's not the counsel, I'm talking about the defendant here, to tell the truth so that our experts could have timely developed their opinions.
Let me ask you this. Did one of your experts give the opinion on deposition that he didn't have a problem with the giving of Levaquin as far as the standard of care? Was that Dr.?
Well, that's Dr. Dreyer. When he got hit with this, he was unfairly surprised.
Okay.
He went through the records and saw no evidence that Levaquin would have been given. And then a misrepresentation was made by defense counsel at his deposition that Dr. Torres had testified. And I don't think it was intentional, to be clear, by defense counsel. But it was not stated in her depot. And then he got asked this, and he hadn't prepared for that. And so, yes, he did say that.
And then that opinion changed by the time of trial.
I think his opinion wasn't so much that about the Levaquin itself, whether no one's contending that the Levaquin caused the ultimate harm here, but there was a consistent, and Dr. Brown, this wasn't a new opinion, Dr. Brown pre-trial said she should have done a culture, and it wasn't just a culture of the nose, she should have done, and he got up at trial and demonstrated this, should have done a culture of everything, and lo and behold, the very medicine that she claimed later to have given as a sample had an insert that said you should do a culture.
What was the evidence that the insert that was presented at trial was an insert that was available to her with the samples that she gave out?
Well, that Dr. Brown testified, and Dr. Curry, the defense expert, acknowledged this in his cross-examination, that these inserts always come with the Levaquin. Now, we've heard all this about, we don't know where it was from exactly. It was authenticated.
How was it authenticated? I thought there was some indication that the insert wasn't necessarily even from the same manufacturer of what she had given, and there was no indication of the date as to whether that was the one being used at the
Right.
time it was given out. Is that accurate?
Your Honor, the threshold for authentication is that their proponent says this is what the document is. All these questions that you're asking and that were asked in the initial brief are questions that can be brought out at trial. Authentication doesn't mean that the trial judge blocks evidence to the jury unless it's conclusively proven what it is. And the cases that they cite in their brief for that demonstrate that. Authentication is a very low threshold. Dr. Brown testified that the package, it's an FDA-approved thing. It's also found in the physician desk reference, which makes it not hearsay for a couple different reasons, and that this was commonly available. And Dr. Curry, their family physician expert, didn't deny that.
Why wouldn't it be hearsay? Explain to me why it's not hearsay.
Sure, there's two ways. First of all, under section 90.803, subsection 17, which deals with compilations that are commonly used by a profession, the Supreme Court of Mississippi, with the exact same provision under their code, which is mirrored off the federal rules of evidence, has held that these inserts that are also in physician desk, PDRs are called, physician desk reference, that those are not a hearsay exception. And the Supreme Court of Mississippi case that we cite in our brief is dead on that. Number two, we cite cases from North Carolina and New York that explain how it's not being used for the truth of the matter asserted, but to show that the physician, and I think it's common sense when you think about it, the physician is giving this medicine, prescribing this medicine to the patient, and part of evaluating her standard of care is, well, what does this medicine say on it?
No, but if it's being used to show that the physician breached the standard of care, then isn't that being used to show the truth of the matter asserted that
No,
breached the standard of care?
No, because all it's saying is that when you gave this medicine, you were told this. You were given notice by the manufacturer about this medicine. Now,
And you should have therefore done the culture, because the document
Right.
says you should do the culture.
now they could have
If that's the conclusion, then that's the truth of the matter, right? The document says you should do a culture. You're trying to convince the jury that she should have done the culture. Why isn't that being submitted for the
Because
truth of the matter?
it's for notice, Your Honor, just like in many areas of the law. So if I come over, if you have a tree on your property, and I come and I tell you that tree looks like it's going to fall because it looks to me like it's leaning. Whether it's leaning or not isn't what's important. What's important is I've now given you notice. And if that tree does later fall, somebody can come into court and say, you were given notice that that tree may fall and hurt somebody. This is the same thing. Whether or not that, in fact, should be done isn't what's important. What's important is that she was given notice about this, and she went ahead and disregarded it.
Did it say you have to take an ear culture, or did it say you have to take some
It said
other-
culture and susceptibility, and there was expert testimony that would include doing an ear culture. And of course,
It's undisputed that the doctor did not do an ear culture, right?
it's undisputed.
And your experts said that failure to do the culture breached her standard of care.
Correct, and that's...
And their experts said the failure to do the culture didn't breach the standard of care.
Correct, and that's the evidence about the breach of the standard of
As a
care.
practical matter, was the insert being used to bolster your expert's opinion by saying, in essence, even the manufacturer says before you use this, you should do a culture?
Well, on the bolstering, I want to point something out that...
And I don't mean bolstering the legal term, I'm talking about the trial strategy to show that your experts were right and their experts were wrong.
And no different than our experts pointing to multiple places in the hospital records that talked about abscess, which is the medical term for giant pus ball. Yes, they were being used to support the expert's opinion. And I want to point this out, all the bolstering case law, the premise of all that case law is that what's being used to bolster is inadmissible. The PDR or the package insert is not inadmissible for two...
But Florida hasn't adopted this sort of learned treatise.
I'm not asking you to change that. All the let's take the hospital records. All the witnesses in this case use the hospital records.
But that's a business record.
Exactly.
But how is an insert in a drug that's anytime you get a medicine, there's an insert in there. So how is that?
So there's two bases for why that's admissible, and the bolstering rule only applies to inadmissible documents. There's just like the hospital records get in under their hearsay exception. Under subsection 17, the PDR comes in during with compilations. The Supreme Court of Mississippi case explains it very well.
Do we have a Florida case that explains?
No, but you don't have a Florida case one way or the other. And the only case they cite is from New York, which is it says one short blurb, and frankly I think is contrary to an earlier New York opinion. Number two, it's admissible to come in for a non-hearsay purpose, which I just explained. I come up and tell you about the tree on your yard, you now have notice. Whether the tree was bending or not isn't what's important. What's important is you have notice that you should have done that. So she by her own late disclosed testimony said she was going to administered this drug. Well, guess what? It said right in there, you should do a culture test. And the reason, I don't think you should get caught up on whether it was the sinus or the ear. The important part that Dr. Brown explained is you want to do the culture test so you know what the bug is. And the problem here, and why this doctor committed malpractice, is she never gave the right antibiotic to kill the bug. Once he got to the hospital, did they give Levaquin? You asked that. The EMTs did. But once they got to the hospital, the people at the hospital figured out that there needed to be a different antibiotic, and they gave 2 other antibiotics. And if this doctor had done that long before, and this was what Dr. Brown testified, Mr. Plummer would be alive today.
Can we move beyond the Levaquin for a minute and talk
Sure.
about Dr. Kelly? Because you would agree that in these medical malpractice cases, it does come down between a battle of the experts at trial for the most part.
Yes.
So in terms of Dr. Kelly and not being allowed, and them being precluded from presenting that doctor's testimony through deposition when the doctor was unavailable, why wouldn't that prejudice the defense in this case?
Well, I think the main argument here and the main objection we made at trial, which frankly the trial judge didn't hold square on though, is that it was completely cumulative. Dr. Kelly in her deposition said, I have no independent recollection of the events as far as the medical events. Her records were admitted into evidence. I believe 5 different physicians talked about her records. It was brought up in closing, to answer a question earlier, by defense counsel. It was completely duplicative and cumulative of things that have already been admitted, and she was not going to testify live. She was not going to testify by video. Her deposition was going to be read, and in her deposition, she was simply looking at her records, saying what her records said. All that came in, Your Honor. So there's just no...
I mean, but it's one thing for a jury to look at you know, records on a piece of paper. And another thing, when you have testimony that's explaining the records, wouldn't you agree?
Not really, no. I think a deposition testimony being read, and all the other doctors, 5 different doctors talked about these records. Having a 6th doctor come in and talk about the records just because she was the doctor who made it.
Well, I mean, you've got all the other doctors talking about the records, but not the one doctor that produced the records.
Right, well, I don't think that gets you, I think that would have been cumulative. I don't think it was an abuse of discretion.
But
I don't
you
think
did
it was
miss
harmless
one thing.
error. I'm sorry?
There is one thing that's missing, even if she says no independent recollection, all I can go on is my notes, and that is her qualifications. Did her qualifications come in otherwise?
They never proffered that. If they wanted to, they could have. I don't think there would have been any objection to that. The objection was to the deposition.
That what, her qualifications weren't in the deposition?
I think they were covered briefly, but I mean, that wasn't the focus of why the defendant wanted to get that in, and there was no mention of that. This is frankly the first I've heard of that. It wasn't mentioned in the briefs. I did want to point...
Was it kept out on the basis of cumulative?
The trial judge made 2 independent rulings, only one of which has been raised on appeal. One was that it didn't qualify under the civil rule, and the second was that the plaintiff, and the one that has not been addressed on appeal, is that the plaintiff didn't have a fair opportunity to cross-examine.
So the trial court didn't do it on the basis of cumulative, which would be a discretionary decision by the trial court, correct?
She didn't expressly cite that, no, that's correct, Your Honor.
Why wouldn't it qualify under the rule to come in?
I think we haven't argued here on appeal that it wouldn't.
Should have come in.
We haven't argued that on appeal, but...
Should have come in on that ground.
Well, yes, but the one thing I would disagree...
The other ground that he didn't address, you think that's a valid ground? That it was taken too early and there was further discovery, and for that reason a deposition can be excluded?
We haven't argued that on appeal, but in this court, in every appellate court, when a judge makes a ruling and gives alternative rulings, and we see this in criminal cases all the time, you need to challenge each and every basis for the ruling.
As you stand here today, is your best argument that it was cumulative?
Yes. Is this 22 minutes or am I up?
No, you got 2 more minutes.
Okay, I did want to touch on something that was said by counsel, and I heard the words, it's a big record. It is a big record, and this trial judge sat through this whole trial, and I want to remind that even if you individually may have made the decision differently, sitting there, there's a great deal of discretion that we have to give trial judges in these instances. And, you know, for example, I heard Ms. Stein say that Dr. Dreyer never testified about a chronic ear infection pre-trial. Well, that's not true. Page 3258 of the record. Mr. Plummer had an ear infection dating back probably at least to November of 2009. Page 3272 of the record. She realized he had a chronic ear infection. So the trial judge, there was a lot going on in this case, a lot more than what you've seen in the briefs. It was a difficult trial to manage. We had instances where the defense counsel was almost sanctioned for violating an in limine order. There were lots of Binger objections that have not been brought up on this appeal. And I think I would really urge the court to go back and read, and I think if our briefs are short in anything, is going through the trial judge's reasoning when she reasoned these decisions. She spent quite a bit of time each time, listened to the arguments from both trial lawyers, and gave an oral ruling. These weren't just off the top of my head. She explained her reasons. And I think I mentioned on the Levaquin about, she kept asking, are you going to have Dr. Torres testify about Levaquin? And if that answer had been no, she probably would have excluded it. I see my time is up.
Thank you.
But just ask the court to affirm, and thank you for your time today.
Okay.
May it please the court, just something I want to point out about the Levaquin in response to what counsel was saying as far as the defense allegedly opening the door. The plaintiffs moved in limine successfully to keep out most evidence and argument regarding the Levaquin, so the defense was going to be prevented from making any argument that the Levaquin somehow helped Mr. Plummer, and that was precisely because there was no predicate, because nobody knew how much she gave, what she gave, and so forth. So the defense wasn't going to be able to say much.
Would it be an unfair statement to say that from your client's deposition that their experts, before they gave their deposition, would not have known about the Levaquin?
Well, first of all,
Well, is that a fair statement?
I don't think so. Well, it depends what you mean by don't know. Literally didn't know because they didn't ask what the record said? Yes, I think that's
Well, she
fair.
made a statement that I didn't prescribe, I prescribed these drugs, she didn't mention the Levaquin, and let's assume, I haven't looked at it, let's assume it's an illegible note, like a lot of our handwriting, a lot of doctors' handwriting. So if that's the case, and the plaintiff's experts are unaware of that, and then they become aware later on, should your client have to bear some of that responsibility?
And Your Honor, it's not the bombshell that plaintiff makes it seem. Before the Levaquin was actually clarified during Dr. Dreyer's deposition, the experts thought it was Z-Pak. I mean, they knew she was given something because I believe Mr. Plummer's wife said he was given a sample of something, and they just all thought it was Z-Pak. So it was during Dr. Dreyer's deposition that they said, no, this is Levaquin. So it wasn't a secret, I don't think, that he was given a sample of something. And I would ask, Your Honor, and the court to look at the preceding paragraphs before the statement in Dr. Torres' deposition, just to see the context and why she fairly may not have understood that that she was being asked about something for sinusitis. The other thing, as far as, if Your Honor's telling me to stop, I will.
Yeah, your time is up. Thank you both.
Thank you, Your
Tough
Honors.
case, well argued. Thank you.